Hey, it's Pete with the Small Business Resource Center and the Small Business Resource Center YouTube channel. I'm here with an update on the NAR commission lawsuit approval. A lot of people have asked questions, they don't know, and I actually took a lot of time to write a letter. I'm going to go over the letter that I wrote because I'm actually opposed to this lawsuit and how they blanketed all of NAR and every real estate agent as criminals because I think it's ridiculous. When you're looking at some things, if you're saying, was there any time somebody may have been lied to? I don't ever want to say that didn't happen because I'm sure it has. Could also be a scenario where maybe some agents, especially newer ones, are not educated, don't understand how the business is, and they also have, you know, said some things they shouldn't have or done things they shouldn't have. Could that happen? Certainly. And that probably happens more than the lying because education is a big component of every job. And when you're looking at a job like being a real estate agent, if you ever take the courses teach you so many things that I think are not important, and they don't teach you about a lot of the important things like how the paperwork is supposed to be done, how ethics are, and a lot of other things. But so you're seeing the NAR settlement. It settled on the 26th of November, which it's the 8th of December right now. And basically, they're saying there's a lot of antitrust issues and a lot of illegal things, price fixing to be among the few things. And I'm going to go into a couple things. But when you're looking at this, one of the things I want to keep in mind as the Department of Justice has actually filed complaints against this, and there's some things that they're for, don't get me wrong, and some things they're against. I actually wrote a very extensive letter, which you're going to be able to see, which for me, I thought I was going to give hope and maybe educate the judge. I don't know who all these attorneys are on the list. We I could spend time to go over them, but from my point of view, I could not see a reason why all of National Association of Realtors and all these companies are liable for illegal things when, in my opinion, in general, there are no legal things going on, especially all of the association and every single person. Now, if you're saying certain people did things wrong or certain companies did things wrong, or maybe there was a group of people or companies that were doing something illegal, yeah, that could happen. And when you're in training as a real estate agent, they actually tell you that, you cannot do certain things. And some of the things are in the lawsuit that they're talking about. So when you're looking at the Department of Justice also objecting or filing appeal on this, you have to ask yourself why. Now, I'm going to go over to things that I know from experience, stuff that I'm educated in. My name's Pete Gustus, by the way. You're watching the Small Business Resource Center YouTube channel. Click like and subscribe, and I hope you enjoy this information. But I'm not going to read it myself. I have a Word document. It's going to explain everything.
Burnett et al. V. National Association of Realtors et al., Class Action Number 19 CV 332. Dear Judge Bough, I write to oppose the summary judgment sought by the plaintiffs in the above-mentioned case. Enclosed are exhibits that substantiate my opposition and illustrate the variability and flexibility of commission structures in the real estate industry, refuting the allegations of price fixing and antitrust violations. Exhibit 1, attached PAR Form XLS, page 1, line 42, paragraph 5. Broker's fee, A. No association of Realtor, R., has set or recommended the broker's fee. Broker and seller have negotiated the fee that the seller will pay broker. Notes: when I started selling real estate, my real estate brokerage stated the following: our company has a minimal commission that we recommend to stay solvent. If we cannot get this amount on a regular basis, we will not be able to pay the staff, keep the lights on, pay you, meaning the agent who brought in the commissionable activity, and pay the bills required to keep this business operational. That being said, please let any client know this is what our company charges as a minimal rate, and if you cannot get that fee, it's up to you to determine if you want to take the client's listing for less than that fee. Keep in mind you still are responsible for the brokerage split and monthly desk fees. With the PAR forms in our BAR Board of Realtors with the company, I have shown evidence that we are not in violation of antitrust or price fixing, Just like in any other business that has prices they use as a company standard, it could be flexible, and most companies will not adjust price if disagreed. In our industry, we can negotiate, and also many other options exist in different companies that do not have the same price structure. All a person has to do is search, and they can find a company that would list a property for less than another company, if that is what a consumer wants to do. All companies do not have the same fee structure, and yet we can understand many are similar, and that is based on the fact that many have similar business models. Exhibit 2, attached PAR Form BAC, Buyer Agency Contract, page 1, line 26. Paragraph 2, Broker's Fee. A. No association of realtors registered has set or recommended broker's fee. Broker and buyer have negotiated the fee broker will receive for exercising professional knowledge and skills in locating and assisting buyer in the acquisition of real property which is available and suitable for buyer. B. Broker's fee, paid by buyer to broker, is as follows: 1. In a purchase transaction. With a seller represented by a real estate broker, the fee is _________% of the purchase price, or _________ whichever is greater, and ___________. Notes: this PAR form, the buyer agency contract, even though a seller has signed a listing agreement, they truly aren't paying a commission to the buyer agent, even though it shows that on the closing documents. The buyer agent's buyer understands buyer agency and the fact that they know if they are getting help from a buyer agent, they have agreed out of the total price they are paying for a home, there is a minimal amount that the agent they hired expects to be paid. Thus, the buyer has agreed to pay the commission, not the seller. Changing buyer agency and listing agency agreements and MLS standards of practice doesn't change this, it just makes it less transparent, more complicated, and doesn't treat all buyer agents and consumers equally. Some buyers who can't afford it won't be able to hire a buyer agent. If a seller says, "No, I will absolutely not agree to pay anyone to assist you." Explaining this further, in my 18-year career as a real estate agent, I have seen and known through other agents that at times if a listing agent commission was very low, a buyer agent would have their total commission increased by the buyer. I can promise a review of HUD sheets and ALTA forms will confirm this, although not always normal. Can't. I, in fact, have told many clients who understood this that I don't let the commission I take steer you away from any home. Yet some have noticed the much lower rate than what I put on a buyer agency agreement and agreed to pay an extra commission because they understood the work it took to help them find a home and do all the due diligence to get them to close. Also a fact that I have had agents state their buyer agent fee is less than what was listed in the MLS, and since they understood buyer agency and the listing contract, they wanted it to be known to the seller that their fee was lower and that amount would be given back to the seller. An example: the MLS listing commission was 3%, the buyer agent was only charging their client 2%, so the seller would only be paying the buyer agent 2% at closing, not the 3% that was stated in the listing agreement and published in the MLS. Exhibit 3, attached PAR Form ASR, Standard Agreement for the Sale of Real Estate, page 1, includes the option on page 1 that states the following: no business relationship, buyer is not represented by a broker. The PAR Form ASR exemplifies the flexibility and options available to buyers who choose not to be represented by a buyer's agent during real estate transactions. This form includes provisions explicitly stating that the buyer is not represented by a broker, thereby waiving any business relationship that would typically involve dual agency or buyer representation. This option is utilized by buyers who prefer to handle their real estate transactions independently. For instance, buyers who are well versed in real estate contracts and legalities may opt to represent themselves to present a more competitive offer directly to the seller. Such decisions are often driven by a desire for autonomy in negotiations and the belief that self-representation may lead to a more favorable outcome in terms of pricing or contractual terms, while letting a seller know that their competitive offer allows them to not pay a buyer agent for their listing contract. In my professional experience, I have encountered instances where buyers have chosen to utilize the PAR Form ASR to assert their self-representation explicitly. For example, an attorney interested in purchasing a property through my listing chose to forego buyer representation, opting instead to submit an offer directly to the seller using the PAR Form ASR. This approach allowed the attorney to tailor the offer to suit their specific needs and present it in a manner that they deemed most advantageous, without the involvement of a buyer's agent. Can't. While this practice may not be considered typical due to the complexities involved in real estate transactions, it underscores the flexibility and consumer choice inherent in real estate agreements. Buyers who elect not to engage a buyer's agent through forms like the PAR Form ASR demonstrate their understanding of contractual obligations and their confidence in navigating the real estate process independently. Exhibit 1 unequivocally demonstrates that no association of realtors sets or recommends broker fees. Instead, these fees are negotiated directly between brokers and sellers, reflecting the diversity of pricing structures akin to standard practices in other service industries. This flexibility ensures that fees are tailored to market conditions and client needs, undermining any suggestion of uniform pricing or collusion. Exhibit 2 further elucidates the customizable nature of broker fees in real estate transactions. It clarifies that buyer's agents negotiate their fees separately from listing agreements, emphasizing transparency and individual negotiation rights between agents and their clients. This practice underscores the absence of mandated commission rates across realtor associations, debunking the plaintiff's claim of systematic price fixing. Exhibit 3, emphasizing the autonomy and options available to buyers regarding representation in real estate transactions. In summary, the inclusion of the PAR Form ASR in this case highlights the diverse options available to buyers in real estate transactions, reinforcing the notion that commission structures and buyer representation are subject to individual negotiation and choice rather than industry-wide standards or price fixing. This is clear evidence that we actually have a clear and transparent market which is fair to all participants. It is my belief for this lawsuit to blanket all of NAR. Every single listing agreement in every MLS area including buyer agency agreements, consumer notices, and settlement sheet needs to be reviewed. For this case to be valid, uneducated consumers feel that since they can search on different real estate websites like Zillow feel they don't need an agent. Much of the information including the Zestimate are incorrect, and without a buyer agent, major mistakes can be made. Recently, a homeowner who recently made a purchase called me and stated, "I bought a home off of Zillow's website only to find out months later after trying to register my child to school, that Zillow had it listed in a school district incorrectly online. In fact, it was in a school district I didn't want to be in." That consumer thought, since I read it online, I don't have to ask anyone. More mistakes like this can occur if buyer agent isn't used, transparent, or trusted. Historically, commission structures in American real estate have evolved significantly. At the inception of realtor associations, commission rates ranged widely from 6% to 10%, with no uniform standard across the industry, but that is what many agents charged. There was no buyer agency at the start of real estate sales, and the Board of Realtors eventually had introduced buyer agency and marked a transformative shift towards consumer protection and transparency in commission negotiations. In the past, if an agent had a buyer, they would ask the listing agent, and often the listing agent would say, "I'm not paying you," so the buyer agent wouldn't try to help the buyer with homes they knew about that were for sale since no compensation was given to them. A transparent buyer agency was created and aimed to address consumer concerns of fairness and representation, ensuring that buyers received equitable services without undue influence from listing agents. This also created increased price competition, as many agents understood they would receive a fair and clear compensation amount, so many buyers agents would bring offers on their listing. Instead of perhaps not being able to buy because they were not treated as an equal when asking a listing agent about compensation for their work when purchasing a property with a buyer they have a buyer relationship with. Moreover, commercial real estate transactions provide a contrasting perspective on commission practices. Unlike residential transactions, commercial deals involve negotiable commissions that vary widely and are not subject to standardized or public disclosure. This variability necessitates clear communication and negotiation between parties to establish fair compensation for services rendered, highlighting the complexity and diversity of commission structures across different sectors of real estate. I would like to explain how things work with commercial real estate, since many consumers think it is fair and the way to go. Cont. I recently helped a client with a lease with commercial real estate brokerage on a lease at 999 Berkshire Boulevard. The listing representative stated that I should include my commission rate with the agreement of sale or letter of intent. I did that by email, and I was verbally told my rate was acceptable. After the agreement was signed, they refused to pay the rate I was told was verbally acceptable, which had been reviewed by email by the listing agent. Keep in mind, many commercial brokers don't have commission rates advertised in commercial real estate websites. The reason, in my opinion, is that they expect that an agent with no experience may put down a rate less than what an experienced commercial broker would ask for. It literally took me 7 months after signing to collect a commission at a rate I didn't agree to because of the lack of transparency and the fact that the listing agent seemed to make excuse and not accept clear and easy to read Board of Realtor forms. If you feel that a buyer agent and a listing agent would negotiate the rates with their sellers at every transaction, this will create a nightmare, less transparency, and an unfair market for many, including buyers that may not be able to add a commission to a sales price. In contrast, instead of eliminating buyer agent transparent commissions, all real estate brokerages, whether they are realtors or just licensed real estate agents, should have to disclose the commission rates on their listings that the owner have agreed to in a listing agreement, so that problems like this don't occur. Let's be more transparent across our industry and not just hold realtors accountable and transparent. Contrary to the plaintiff's allegations, there is no evidence of uniform commission rates among real estate professionals. Reports from credible sources such as Forbes and Investopedia cite commission rates typically between 5% to 6%, reflecting market dynamics and consumer expectations rather than collusion among industry competitors. That is based on facts and business models, just like every other industry can be said to have standard pricing. Yet, realtors have made it explicitly clear they do not have standard pricing. Cont. The comparison drawn by the plaintiffs between real estate commission practices and attorney fee structures is flawed. Attorney fees are negotiated individually with clients on a contingent fee basis, reflecting the complexity and specific nature of legal services. The standardization of contingency fees across legal websites merely reflects industry practices and does not imply collusion or anti-competitive behavior, as asserted by the plaintiffs. Attorneys give a bill after work is done and many clients don't know what their will is until they get it. Wouldn't attorneys charging standard 25 to 40% be involved in antitrust and price fixing? I'm pretty sure it's easy to find that what is what most attorneys charge after winning a lawsuit like this. And that not in addition to hourly rates they charge on top of the commission rate they receive and not disclosing those total rates until a final bill comes. If you believe I'm wrong, Google it. Let's sue these attorneys. Let's be serious when it comes to transparency. A seller acting through a realtor clearly understands their fee structure, and if they don't like it, they are always welcome to go to another company or person or sell it themselves as a for sale by owner. In conclusion, the evidence presented refutes the allegations of price fixing and antitrust violations within the real estate industry. Commission rates are the product of negotiation, market dynamics, business models, and consumer choice, not collusion among competitors. The localized nature of real estate agreements, coupled with historical context and market variability, underscores the lack of merit in the plaintiff's claims. Therefore, I respectfully urge Your Honor to dismiss this case as frivolous and without legal basis. The evidence provided demonstrates that commission practices in real estate are transparent, competitive, and driven by consumer choice and market conditions. These choices lead to a transparent market which is open and honest to all consumers, both the sellers and the buyers. Thank you for considering my opposition to the summary judgment motion. Should you require further information or clarification on any matter discussed herein, please do not hesitate to contact me. Sincerely, Peter B. Gustus.
So when we're looking at this, one of the big things that I think is a big issue is the simple fact that they're talking about disclosing a legal agreement. And when you're looking at that, why is that an issue? If people are disclosing a legal agreement, they always have the option to accept it or reject that agreement. But when you're not disclosing it, that seems to cause a lot of problems. Buyer agency basically calls for price discovery and more competitive, not less competitive. And when they're talking about disclosing commissions, it seems like this wasn't really an issue until certain companies started advertising the commission rates that were online. And when companies start doing that, people are like, well, what is this? What is that? Well, why does it have the commission rates? And I shouldn't be laughing, but in the past, the commission rates typically were just something an agent would see. So most of the agents, well, I can't speak for anyone else, but most of the agents would look at that commission rate and see if it's acceptable. If it's not acceptable, they can actually request a different amount. They could also request that their client make up a difference of an amount. But if you understood my letter, a lot of times I actually would always just accept the commission rate that was given by the the listing agent. And when you're looking at that, sometimes that listing agent is a foreclosure, and those foreclosures with the government, a lot of times they actually paid a much lower rate than a regular listing would pay. Does that mean I do not help my clients with those properties? Absolutely not. I would always help my clients with those properties. So when you're looking at this information, I hope this made you more of an expert and understand the buyer commission information, the NAR lawsuit, and why this should be appealed. Because when it comes to being transparent, more transparency makes all of our jobs easier. What we were told to do right when this started is you're supposed to call, text, or email somebody before you have an appointment and ask them if you're going to get a paycheck or not. I mean, I tried to do this for a couple days, week or 2 weeks. Most of the times, a lot of agents don't even respond. When it came to how I used to do business and how I now continue to do business, now I actually just set up the appointment. And then if my client is interested in putting an offer, I ask what the rate is that they're expecting to pay. And if it's not a rate that I have already signed an agreement to accept, I ask for more in the commission structure. Does that make sense? Hopefully it does. But anyways, what are your thoughts and comments on the NAR lawsuit? I personally got the documents in the mail because I have sold property that I owned, and I basically threw it all in the garbage. But because I really think it is garbage. But when it comes down to it, I'm shocked how they're sending everybody these papers and saying, hey, you were cheated or you're screwed over. Because if you look at the facts of the things that I put historically, even before buyer agency, people were paying 6 to 10%, and sometimes even more in certain areas, and it was considered normal. And there was no buyer agency. So what buyer agency did was they just decided, okay, I'm going to offer this compensation to a buyer agent, and if that's me, then I would get both sides of the commissions, whatever was in the listing agreement. So does that make sense? Hopefully it does. Well, this is Pete with the Small Business Resource Center. Like, subscribe, comment. Let me know your thoughts and have a great day. I hope this gets appealed.